Hey everyone, my name is Altagracia Pierre Outerbridge. I am a landlord tenant attorney located in New York City. I am here to talk to folks today about the latest extension to the eviction moratorium, the eviction ban in New York City, and how it may or may not affect you. So, as some of you may know, on May 7, 2020, Governor Cuomo issued an extension to the current moratorium. The current moratorium, which ends on June 2020, Governor Cuomo issued an extension of that moratorium through August 2020 for certain categories of New York City tenants. What is the extension? So as I just said, it's from June 2020 through August 2020, right? There is an unconditional moratorium currently through June 2020, which covers all New York State tenants. So we're talking specifically about the extension to the moratorium, which goes through August 2020, and who it affects and whether or not it affects you, and what are the other points in it that may be of importance to you. So this moratorium, the umbrella of the moratorium, the big picture is that it covers both commercial and residential tenants, right? It prohibits a landlord or the commencement of a non-payment action or foreclosure action for non-payment of rent, right? We'll focus on the landlord part, the landlord and tenant part. It prohibits a landlord from commencing a non-payment action against a tenant. We'll focus right now in New York City. Against a tenant in New York City, it prohibits a landlord from commencing a non-payment action against a New York City tenant, right? Through August 2020, if that residential or commercial tenant is eligible to receive or receives unemployment insurance or benefits at the state or federal level, or if that commercial or residential tenant is financially affected by COVID-19. So how does that play out in real life? How does that play out in real life? How would a landlord know whether or not to start a case, whether or not you fall into the protected categories of tenants? The administrative judge of the civil court, right, of the city of New York, has issued directives as to how that should play out in court. So according to the directives, a landlord may not commence a non-payment action against a New York City commercial or residential tenant without an affidavit from a person with knowledge that that tenant does not fall into one of these two categories of protected tenants. So no landlord can commence such action without that very necessary affidavit. So how would the landlord really know? If the landlord doesn't know, the landlord then cannot and should not submit such an affidavit without knowing, right, having good knowledge of this information. That leads to, if the landlord doesn't know, the landlord cannot start a case against you until after August 2020. So we talked about how that plays out in life, in real life, in a court proceeding, right, in your interactions between you and your landlord. We'll talk now about what that executive order says about security deposits. So the executive order, in order to alleviate some of the financial stress that folks in New York City, tenants in New York City are feeling, it provides for an amendment of the general obligations law in that your security deposit can now be used for payment of past rent arrears or of future rent should you choose to do so. So it's solely, one interesting point in this is that it's solely at the tenant's discretion that only the tenant can elect to use their security deposit for the payment of arrears of future rent. The executive order specifically says that it's at the election of the tenant that the landlord cannot coerce such election. The landlord cannot force you to use your security deposit should you choose not to. It goes into detail. The executive order goes into detail as to the repayment of this security deposit, when you should repay it. Repayment, it says that repayment cannot start less than 90 days after you use it, right? And it provides for 1/12 of the payment, right? So every month you pay 1/12 of the security deposit until you fully replenish it. Another important point of this executive order, of May 7, 2020, is that it provides that no late fees, the landlord shall not seek to obtain late fees for any rent that was due from March 2020 through August 2020. We talked about which type of tenant this moratorium covers and what kind of cases, right? It covers folks who are financially impacted by COVID-19 and folks who are eligible for unemployment benefits, or it only talks about non-payment action. There's only a ban on non-payment or foreclosure for non-payment, right? What does this executive order not cover? It does not cover other types of cases. So it is understood that until June 2020, the moratorium is in effect. After June 2020, extension does not cover a ban on the landlord commencing other types of cases, i.e., right, while the landlord is forbidden from commencing a non-payment action unless if a tenant fits into these two categories that we discussed, there is no ban against a landlord commencing a holdover proceeding, right? There's no ban against a landlord commencing an ejectment action, right? Other types of actions against tenants which have the same effect of requiring the tenant to pay rent as an ancillary, i.e. as an additional remedy, as an additional relief in their case. So there are shortcuts. There is a loophole in that executive order, in that landlord may be able to commence another type of action and still seek payment of rent in that action. So that's it for today about the latest on the eviction moratorium. My name is Altagracia Pierre Outerbridge. My firm is Outerbridge Law PC. Our phone number is 212-364-5612, and have a good night.